Have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Surgery bar from Ms. White.
And are you Ms. White? Right, the defendant entered a plea on July 12th, and she applied for deferred adjudication. According to the plea bargaining agreement, punishments be assessed at 5 years in the prison. There's a $1,500 fine. The state is remaining silent on the application, and they're taking in consideration 2022 CR 0814D. There's an affirmative finding of family violence and no contact with Alexander White and Kayla Connor. Have both parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, ma'am.
Any objections? State?
From the state.
Defense?
No, no defense.
All right, the state is silent on the application. Is there anything you wish to say on behalf of your client?
Yes, ma'am. Thank you. From the very beginning of our representation, Ms. White has been probably one of the most diligent clients as far as keeping up with her case, with her settings, coming to see me, talking about it. And I would say from the very beginning, just our I guess plan for this case was about taking responsibility and doing everything she could to report that she would be a good candidate. She has gathered, and sometimes it's hard to wrangle a bunch of people to do letters of support, but she has gathered 6 letters of support that we have. I had not filed them with the court judge. I had them here, and I wanted to let you know and spoke about her. But if the court would like to see them, the state has had an opportunity to look into it. That way, when you work with something.
All right, any objection to the state viewing the letters? I'm sorry, to the court reviewing the letters.
No objection.
What I'm interested in, even though the state is taken in consideration, and I look at everything as a whole, is that she had an injury on June 22nd, and it is assault on July 15th. Now, understand that assault is involving her niece, and her niece, I guess she did an affidavit of non-prosecution. She doesn't want to be a part of it. She thinks that she shouldn't be even on probation for this. So I understand that. So we're going to put that to the side for a minute. I want to know what is happening with this injury. What is that about?
So to be very general about it, Judge, there were quite a few people during the pandemic that were living in an apartment, a single apartment. The primary case, without getting too deeply into any conjecture or anything like that.
Yeah, and honestly, with regards to the injury to the child, if people want to say allegedly, I'm fine with everything you're about to say. I'll put allegedly in my mind in front of it, but I want to know what's going on with that so I can make a decision on whether or not I should grant her application.
Yes, ma'am. So my understanding is that the child is actually the son of an individual living in that apartment, Brandon White. I believe he has taken a plea on this case and is currently serving for this. Ms. White was residing in that apartment with her husband at the time. They had kind of a separate area. The way that the apartment was set up, they were living in a separate area. During this period of time, I don't know that this is, I believe there will be several witnesses that can attest to this, that she worked these long shifts during that period of time. They pretty much spent all of her time, or the significant amount of her time there at these shifts. They didn't have a whole lot of interaction with the victim, if you will, in this particular case. However, her name was mentioned in the interview of the victim. And so that's, I believe, just having the fact that these people were all in this apartment that resulted in these charges.
All right. Do you have any objection to the state telling you what's in their file?
No objection, Judge. Obviously, just for factual purposes. All
right. I'm putting it allegedly in front of everything in my mind. State, can you tell me about the injury to?
Yeah, Judge, just to give me a minute to refresh my memory. I'm sifting from Michael, but
Okay.
and it's taken into consideration. The defendant was indicted on that one, count 1 for striking the victim with the paddle, striking with the belt, striking with the hand, and then count 2 by omission, causing bodily injury, because she assumed fear, custody, and control of Alexander White.
And I don't know if both of you all want to step back and address what's in the police report and then come back up.
Okay.
Yes. So if defense and state, if you can look over that so it can help me make a decision on her application.
Okay.
All right.
Just to confer about what's in it to address the court?
Yes. So we are back on the record. Ms. White, if you can come forward. And again, I'm taking this as allegedly. All right.
And
Yes.
Judge, the child in this case was taken to the hospital, and there were several co-defendants. That he did make allegations that the defendant in this case spanked him, hit him with a paddle, hit him on his chin. She admitted to spanking him. She said she got the paddle as a deterrent, but had never used it on him. She also admitted to spanking him with a belt 3 or 4 times. So there are admissions that she did cause an injury, and the child himself did say that she caused an injury as well.
All right. And again, I'm putting allegedly before in my mind. But is there, do you want to call your client as a witness to address these issues?
I can address them, Judge, unless the court.
It may be best for her because, Ms. White, what I'm looking at, and I know the state is taking it in consideration, but I have technically before me 2 violent offenses. One is the injury to that was alleged to have been committed on June 22nd, 2021. And then a month later, we have this assault choking from July 15th, 2022. And so I'm trying to figure out whether or not I should grant your application. And I need more information that's not in the PSI report. So if you raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, defense, do you have questions?
Yes. So, Kayla, if you could just explain the prosecutor was an opportunity to kind of focus in the and I know that you would want to get some conclusion. So we can address the court regarding especially
so during the time that Raymond proceeding, my name is here on the case, he called both of us Aunt Kayla. He did not discern between which Aunt Kayla's. Raymond never discerned that it was his girlfriend to his child. And I had to explain to him, I said, do you understand that you were basically dating your step niece and you have to explain like this all to your child? We went through that bundle. We explained to Brandon and Kayla that since they decided to date each other instead of taking care of what they needed to for their own children, we were going to step back and stop as far as we would help them with a place to stay until our lease ended. And after that, we were rendering no more help to them. The last time I had spanked Alexander had been in December of the year prior. And after that, I had spoken with Brandon and he said that he would check because when I did spank him, Alexander had moved and jerked. And so when he did that, I stopped. I told Brandon, I said, look, since he's moving, he's jerking, I will not spank him any longer. I won't recommend him. You need to be the one to do this. You're his dad. You need to be the one that steps up. And
real quick, and just to talk about what was said. You explained, did you ever strike Alexander?
Yes, I never struck him with the paddle. I spanked him once with my hand, once with the belt, and I never spanked him again because he jerked both times. And my last thing was I didn't want to injure him.
And so, as you heard, Judge Boyd is talking about the fact that there's a few different cases in a certain period of time. And so, I know that you've had an opportunity during the PSI interview, Joseph, but regarding that specific instance, it was involving the kid. Okay. And so, if you could just explain to Judge briefly what transpired.
I had asked Kayla to wash the dishes that have been similar for several
Okay, and just so both parties know, I've read the PSI report.
Very good, Judge.
Yes.
Okay, just want to make sure.
No. I always read the PSI report with a fine-tooth comb, and I've read all the police reports.
And I didn't want to be too redundant, Your Honor. I apologize.
Oh, no problem. I know, just so everybody knows, everything that's put in front of me, I always read it. Like every single line, every comma, every semicolon, I always read it.
Very good.
So, I still have concerns with the injury to case, even though it's being taken in consideration in this case. And the state is silent, but,
This is where the hearing takes a dramatic turn. Judge Boyd isn't just checking boxes on a plea agreement anymore. She's digging into another alleged violent incident. Even though the prosecution is staying silent, the judge still has a duty to decide whether probation is actually appropriate. That's exactly why she's asking the hard questions.
I think we need to reset this and state if you can explain to me or have someone explain to me why that case is being taken into consideration. I don't know. Maybe it wasn't provable. I don't know. Maybe there's some other reason or some information that they have that I don't have access to, because I don't know anything about that case other than what the charge is. And I'm just a little bit concerned that we have two violent offenses so close together. So, state, will Mr. Villarreal be here tomorrow?
Yeah, Judge, he should be here tomorrow.
Okay. All right.
And Your Honor, if there was a specific time that the court wanted us here, I know that, and this is just me asking on her.
Oh, no.
I know that she does work tomorrow, and I know that this is more important.
When is your next off day?
The next off day would be Wednesday.
All right. Norma, are we able to fit this in here Wednesday of next week? So let's just do a Wednesday at 9. Everyone needs to be here exactly at 9 a.m.
Very good.
Okay. All right. So we're back here for sentencing. The defendant had applied for deferred adjudication. The court, because it wasn't noted on the docketing sheet, the court reviewed the stipulations and found there was sufficient evidence to find her guilty, but deferred finding of guilt. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State is remaining silent. They're taking in consideration 2022 CR 0841D. There's an affirmative finding of family violence and no contact with Alexander White and Kayla Connor. And we're back here because the court had an issue with 2022 CR 0841D. So have both parties had a chance to look into that case?
Yes, ma'am.
All right, so give me information.
And I can tell you, Judge, I know we're silent, so I'm just trying to speak about factual issues. Is being taken into consideration in the sense that, I guess, two parts. Number one is that she has stipulated as part of stipulations to this, I believe, part of the indictment on the second case, so she's taking accountability for that portion. That's partly why. Number two is that two of the co-defendants, which is Kayla Connor and Brandon White, have taken responsibility for their part of the actions. I believe Brandon White actually went to prison because he's the main actor in that case. And then third, it was just, as you are aware, being a former prosecutor, it was made in consideration to prevent a child witness from having to testify unnecessarily when we have the same degree of offense for both cases.
All right.
And Your Honor, to speak to the case, I've spoken at length with Ms. White. I've really thought back over all the case, the other case that the court has been asking about.
Okay, you're whispering.
I'm sorry. I've had a chance to talk to Ms. White, and I really had a chance to look over the case and think about the questions that the court asks on this. I think the conversation I had with Kayla immediately after this past week, and we had a chance to kind of sit down and talk.
Voice up.
I'm sorry. I usually try to project.
Brenda, this is he's lowering his voice. You remember, I know people don't listen to the radio anymore, but they used to have secret storm or whatever, and people have the low voice. So if you could put it up here.
Right. You know, Jed, and I think it might be my allergies. I'm susceptible to mold, so my apologies if that's what it is.
Barry White had a low voice, but you could still hear everything he was saying.
Sometimes I try to pull it.
Okay.
Doesn't always work. But to continue, Judge, whenever our conversation was really telling, Kayla was very emotional in speaking about it, and she has been in the past. So the way just to lay out the facts of the situation, she was residing in this apartment, decent sized apartment with her husband. The COVID pandemic occurs, and Brandon White, who is the father of the child in the other case, implores them to allow him to move in there during the
Oh, no, I remember the facts of the
Yes,
case. I'm just trying to figure out what, honestly, the taken in consideration, which has been explained by the state.
Yes, Judge, and I'll be very brief. The way that in our conversations with the state and going through it, I think Michael is spot on. That Kayla's always been willing to take responsibility for any part that she played in any of this. I think it's very clear, and the way I've explained it, and this is me advocating for her as well. She's working as she does now, lengthy hours, and when she's home, most of the time she's sleeping. In talking to her, it's very clear in this case that Brandon White, the individual's, Alex's father, the child's father, essentially had the most interaction with the child. And he lived sort of a secretive life. I don't know if secretive is even the right word to put there. They lived their lives, and Kayla, to the degree that possible, continued to try to live hers. But when you talk to her about it, and I've related this to the state, that does she wish she was more perfect? Does she wish that she could have done, looking back on it, could have maybe done more or done those things? Yes, of course. I think everyone wishes they were perfect on things. But I truly believe, Your Honor, that she thought she was doing best, that she was trying to play her role, and that she trusted that that the child's parent, would be taking care of things in a responsible manner. Having a chance to look at the case in total, to look at Kayla White's role and everything, and what could have been done. I do not believe that I personally do not believe that she is guilty of committing any abuse or violence toward Alex. But again, that's part of the conversation that we were having here, is that I think that when you look at the roles that were played here, Kayla White's role, while she will be the first to admit she could have done maybe more, was not the one that was resulting in the injury to the child. And so I think for those reasons, Judge.
I'm sorry, just one moment, that interruption. That was a medical call. All right.
May I proceed?
Yes.
And so looking at the case and looking at the situation with Ms. Connor, everything, the letters that I presented to the court last week, I think the picture that is painted is one that I believe of her that is within my sense of her, which is that she's always going to do her best. She wants to do her best, always. Will she make mistakes in life? Absolutely. But she's the type of person that will do whatever she can to make amends for those, to do better for herself, for her family, for her community. And I think that in the court's mercy, should she be provided and allowed to do a deferred adjudication, community supervision, the court will see that she will attend all of her appointments, do what is asked of her, not just the bare minimum, but beyond that. That's the person that I know her to be. And I think that's the reason why we're here today in this specific situation.
All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God? All right. You're going to have to speak up.
Yes, ma'am.
All right. Could you state your name for the record?
Kayla Lynn White.
All right. Where are you living?
I am currently living at 5711 Cuba Road in Seguin, Texas, with my general manager and her mother.
All right. Are there any children in that home?
No.
All right. Where's your husband?
He is living with a friend, as far as I know of. I don't know which friend, and I don't know where.
Are you all still together?
We are still married.
But no. Are you still together? Are you still in contact?
No.
What's his name?
Christopher White.
So is she asking that her probation be transferred to Seguin, or would she be staying in Bear County?
Either way is fine with me. If it's in
No.
San Antonio, I'll take it.
No, let's not do the either way.
It would be Seguin, Judge. I think that would probably, just knowing these things, I think it would probably be best.
So are you asking that your probation be transferred to Seguin?
Yes, Your Honor.
Probation, is that possible?
Your Honor, it won't be transferred from that account. It will still be supervised here.
Okay. All right, the court will follow your plea bargaining agreement. There's a $1,500 fine. That will be probated. 5 years deferred adjudication. Take in consideration 2022 CR 0841D. There's to be no contact with the following persons: Christopher White, Alexander White, Kayla Connor. There's to be proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Defendant is not allowed to reside in any household with minors. There's to be no unsupervised contact with minors. There's an affirmative finding of family violence. There's to be regular reporting by Zoom or in person. If you're drug tested today, what are the results going to be?
Negative, except for my medications that I'm currently taking.
What medications?
It is a generic Lexapro. I can't pronounce it. It's Calicram or something like that. And I also take trazodone for sleeping, but I haven't taken it in a week because I haven't needed it. I've been too exhausted.
All right, what are you on those medications for?
Trazodone for sleeping because I have severe insomnia, and the generic Lexapro for my bipolar disorder.
All right. I'm going to ask for a MIC evaluation. And the defendant, you're going to have to sign a release so that the probation can have access to any of the medications and doctor's reports. There's to be regular UAs, field visits, one time per month, random. And that's until further notice. State, it's not listed in here. Are you all requesting any type of classes? Because there is not a BIP class listed or anger management.
I think it's because we were silent, Judge. We didn't make any.
Okay, thank you. All right. The BIPP course. All right. And State, I know you're silent, but now that you know there's the court is granting her application, is there any condition that you think would be helpful for her? To her?
Not that I could think of, Judge, other than Christopher White is a fugitive from his court.
Mhm.
So I hope that if she does not have that information, but if she does, that she